Good afternoon, everyone. We're just letting people in, so we'll leave it for a minute or so before formally beginning, just to allow people to find their way into the webinar. Well, good afternoon, everyone, and welcome to this Francis Taylor Building Public Law webinar. The topic for today is acting for interested parties and interveners in judicial review. For those who don't know me, my name is Richard Honey. I'm a barrister at Francis Taylor Building. I'm chair of the Public Law Practice Group and chair of this seminar. I'm very pleased to see that so many have booked and logged in for the webinar today. You are, I think, probably by now very familiar with Zoom webinars. We're going to try and keep it simple in terms of the technology in any event. So we'll be taking questions via the Q&A function on the system. You should be able to access that by clicking on the icon at the bottom of the screen. The Q&A icon should appear when you put your cursor over the bottom of the screen. Please do feel free to type questions or comments in the Q&A function as we go. We'll answer the questions in a block at the end after the talks, or at least as many as we've got time for. We're going to aim to stop not long after 2 o'clock, even if we've not got through all of the questions, but obviously feel free to email me or the speakers afterwards if there's any burning questions which remain outstanding. Please don't try to use the chat function, use the Q&A function. We're going to ignore any of the chat messages. All being well, we'll be sharing screens to show PowerPoint slides during the presentations, but we'll also email copies of the PowerPoint slides out afterwards. And we are recording the webinar, and the recording may well be published afterwards on the FTB YouTube channel. So the webinar today is going to cover how best to represent interested parties and interveners in judicial reviews and similar statutory challenges in the administrative court and the planning court. It's directed towards organisations who might find themselves in that position from time to time, including government bodies, local authorities, regulators, developers, operators, and public interest organisations. And we hope to cover both strategic and tactical considerations and procedural matters as well, giving practical tips on how to effectively participate as an interested party or an intervener to protect or promote your interests. We're going to be covering practice in England and Wales, but the practical advice will be generally applicable in other jurisdictions, including Northern Ireland, for example, albeit, of course, the procedural rules do differ. We've got two speakers today, Hereward Phillpot QC from Francis Taylor Building and Jasveer Rhandawa of Herbert Smith Freehills Solicitors. Harry will be considering practical and tactical issues for interested parties in judicial review type litigation, and Jaz will be covering the role of an intervener in public law litigation, including the practical considerations. I'm going to introduce each of them as they come to speak. And as I say, please do type questions into the Q&A function as we go. So I'm going to start now with Harry. Harry specialises in planning and environmental law, judicial review and statutory challenges in the planning and the admin court. He acts on behalf of the government, developers, local authorities and third parties, and in particular has expertise and experience in dealing with nationally significant infrastructure projects and other major developments like airports. Harry took Silk in 2015, having served on the Attorney General's A, B and C panels of counsel, and he is in both Chambers and Partners and the Planning Magazine survey, top 10 highest rated planning silks overall. So Harry, if you could share your screen now, please, and then begin your presentation. Thank you.
Thank you, Richard. I hope you can see my slides now. I'm going to be talking about the following matters over the next 25 minutes or so. First of all, when and why an interested party might want to take an active role in judicial review or similar litigation. Then some points about procedure, costs and cost protection. Then the duty of candor and its implications for interested parties. Then cooperation with the defendant, some tactical considerations, and then to look at the end point of the process, consent orders, quashing and redetermination, and how an interested party should approach those parts of the process. So starting then with when and why to take an active role, and I'm going to consider this from three perspectives. First of all, the perspective of an interested party wanting to help the defendant, then an interested party wanting to help the claimant, and then thirdly, some reasons why you might not want to get involved in some cases. So looking at it first from the perspective of an interested party who wants to help defend the decision. And sometimes the interests of the defendant and the interested party are not wholly aligned, and that might be a reason to get involved. And the lack of alignment may relate to individual aspects. It might relate to motivation and the outcome. And so as an example of that, just to illustrate the point, if you look at the challenge to the airport's national policy statement, where the Secretary of State was, at least initially, defending the claim, but was joined in that by Heathrow Airport Limited. And the separate nature of their degree of motivation in defending it can be seen in what then happened later on when the MPS was initially quashed. And we'll come back to that in another case in another context. Secondly, that there may be some instances where the defendant is going a bit wobbly or just choosing not to defend the claim at all. And there the role of the interested party may be partly to shore up the defendant, to try and put a bit of backbone into them by identifying ways in which the claim can be defended, or alternatively, if the circumstances warrant it, taking up the defence themselves if the defendant decides to consent to judgment. One of the reasons why an interested party might want to get involved is connected to the question of resources. An interested party may have deeper pockets than the defendant and access to greater legal resources and generally have the ability to spend more time and money on the case. And that can be particularly the experience of those who are defending decisions on behalf of local authorities, where a developer seeking to support it may have access to a whole range of legal resources that the local authority might not itself be able to fund. Importantly, there are a number of cases where the interested party will have a greater knowledge of the facts. And that can be seen, for example, in many cases where the Secretary of State is the decision maker, but there's been some form of detailed adversarial process beforehand, a public inquiry, for example, because the Secretary of State's legal team will have had no involvement in that process. They will be less familiar with the evidence, less familiar with the arguments that were advanced, and therefore not be as alive potentially to some of the things that underlie the decision that they're seeking to defend. And there the role of the interested party, with its legal team probably having been involved in some detail in that process, can be very important. It's also possible, of course, that there may be different lines of argument that the interested party would wish to run in order to increase the chances of success, as well as supporting those that the defendant itself is running. Secondly, looking at it from the perspective of someone who wants to assist the claimant. It's often the case that an interested party will be seeking to help defend the decision, but not always so. And a party can join as an interested party in order to assist the claimant. And I've given an example there in the second bullet point, Ledyard, where the interested party was the landowner and the claimant was the disappointed would-be developer. But it could equally be on the other side. You could have a claimant who's a local authority and an interested party that's a residents group or other body seeking to resist development or support the local authority. And the procedure doesn't make specific provision for an interested party in that position to serve summary grounds for supporting the claim at the acknowledgement of service stage, but it does make specific provision, as I've identified in the slide, for an interested party supporting the claim to put in detailed grounds. But of course, that only happens after permission is granted. And that's then reflected in CPR 54.9, which makes provision for a person who doesn't acknowledge service but complies with Rule 54.14 to take part in the substantive hearing, albeit it also makes clear that that can be taken into account when deciding what order is made as to costs. So one of the things which, both from that perspective, protecting your position in costs, but also just in terms of making the process run smoothly, there may be some circumstances where the interested party might want to volunteer summary grounds for supporting the claim on additional grounds initially, so that those can be considered at an earlier stage and reducing therefore the costs risk associated with only intervening later. But of course, before deciding to wade in, it's necessary to consider the potential risks and downsides of doing so. Now, if the interested party is not adding anything substantive to what the defendant is saying, it's unlikely to be worth the cost. And there are a surprising number of cases where that is what happens. But it may be that the interested party can see that there's a useful role in finding additional evidence of the facts, whether that's documents, accounts of what took place at some point in the process leading up to the impugned decision. And if that's the position, the interested party could choose to get involved only to the extent of putting in a witness statement and not necessarily appear in court. But it's also important to understand that the interested party's role is not confined to what goes in paper or what goes on in court itself. Quite often, the position of the interested party can be to assist the defendant who's bearing the main burden of defending this by suggesting points, identifying potential weaknesses and how they might be addressed, and generally helping the defendant to put on a strong defense. And sometimes when you get to court, that might manifest itself in not having much to say because you've already fed your input in at an earlier stage. That doesn't mean it hasn't been important, but just sometimes the actual assistance is not apparent to the judge. Secondly, there are circumstances when you're appearing for a defendant, and I've had this on a number of occasions, acting particularly for the government, when you're defending a Secretary of State decision or an inspector decision, where actually the presence of counsel for the interested party can be positively harmful. And a lot will depend on who turns up and how good they are at spotting where the subtlety might lie in a case and the need to tread carefully. There are some advocates who simply turned up and aggravated the judge, harmed your case as a result, or also go off-piste, potentially drawing attention to things that you might rather no one focused upon. So there are some practical points that you can do to try and reduce that risk, mitigate that harm, and I'll come on to those in due course. But sometimes it just depends on who is instructed. And litigation, of course, can be expensive. You have to bear in mind that if you intervene and your side loses, there is a risk that you might have to bear some of the costs, and I'll come on to that in a bit more detail in due course. You also have to consider that if you get involved, there's the duty of candor to wrestle with, and again, I'll come on to that in a moment. Beforehand, though, I'll look at the question of procedure and costs protection. First of all, the pre-action protocol. There's no obligation for an interested party to get involved in the pre-action protocol, but experience suggests that it is often, indeed perhaps generally, worth doing so. It can be helpful in terms of cost, particularly if the interested party, you have identified the point or a point on which the claim is ultimately defeated, or if you're helping the claimant on which it is ultimately successful, and you made that point before litigation even started. That can certainly help your case for getting some share of costs. And also, frankly, it can often help achieve the objective at an early stage, sometimes without the need to go to court at all, whether that's because the defendant consents to judgment or alternatively because a challenge that might have been made is deterred. So far as the acknowledgement of service is concerned, the word there, mandatory, is subject to the caveat I mentioned earlier in terms of the position of someone supporting the claimant. But generally speaking, if you want to take part, and certainly if you want to take part to help defend it, you must put in your acknowledgement of service. There are similar advantages in doing so to those associated with being involved in the pre-action protocol, with the added point that, of course, if your submissions appeal to the judge who's determining it on the papers, then the effect that that can have on the other side is magnified as a result, because your arguments are then shown to be, if you're for the claimant, at least arguable, or alternative, if you've succeeded in knocking the claimant back, that will dent their confidence somewhat. And then the point about detailed grounds there applies whether you're on the side of the claimant or the defendant. And I want to look at the position in terms of costs in favour of an interested party. And I've started with reference to a case which is ongoing, and the report there, the references to the Court of Appeal decision, is currently sitting with the Supreme Court, who I understand have heard argument, but judgment is awaited. It's an important decision, and you need to keep an eye out for what the Supreme Court says about it. But what it deals with is the liability of the claimant for more than one set of costs at the paper permission stage. It doesn't deal with the costs of an oral renewal hearing, which is covered by separate provision, obviously in the civil procedure rules. But what it does is it clarifies that there's no need for an interested party to show exceptional or special circumstances to obtain a second set of costs against the claimant in relation to the acknowledgement of service and the summary grounds. But those costs must be reasonable and proportionate. And looking at those issues of reasonableness and proportionality will generally involve the court considering whether the interested party has added anything and whether it's been helpful to the court. But if it has, if that has been the case, then there isn't an additional hurdle to clear of showing that the case is somehow exceptional. Just to be clear, the substantive stage, however, as the last bullet point makes clear, the approach is still covered by the familiar rules set out by the court in Bolton. So an interested party is not generally entitled to their costs at the substantive stage unless there's a separate issue or interest that requires separate representation. So there the bar does seem to be still set rather higher. The other point just to bear in mind, as I've indicated there, is what the admin court guide says at paragraph 23.6.1, which is that a second set of costs against the claimant is less likely if the claimant is acting in the public interest rather than for personal gain. Next thing to look at is the provisions and the practice in costs being awarded against an interested party. Now that is, it's less usual, it's unusual, but costs can be recovered against an interested party in admin court proceedings in appropriate circumstances. So for example, if for the interested party, you choose to go beyond the defendant's case and to run additional points, and those additional points are unsuccessful, then you take the risk that that will lead to a partial order for costs against you to account for the extra costs that the other side have had to incur in dealing with the points you've run. So there is a trade-off there between the potential advantage in helping your side by taking additional points, as against the risk that if those points do not ultimately attract the judge, you might bear the costs that everyone on the other side has had to incur for dealing with them. There's also the issue of costs if you have decided to fight on when the defendant has consented to judgment. And I've given an example there of a case, but it's not an uncommon set of circumstances where the interested party, who in that case was a beneficiary of a planning permission granted by the defendant, chose to fight on when the defendant did not. Unsurprisingly, from the point at which the defendant agreed to consent to judgment, the rest of the costs were to be borne by the interested party. And finally, under this heading, if the defendant accepts that the claimant is entitled to Aarhus protection in respect of their costs, but the interested party resists that, well, if you don't succeed in resisting it, then you pay the costs. So costs risks do exist for interested parties, and they need to be borne in mind when you're taking a decision both as to whether to get involved, and if so, quite what to do once you are involved, and the extent to which you do or don't depart from the defendant's line. Finally, under this heading of procedure costs and cost protection, an interested party, as opposed to a claimant, can't apply for an Aarhus cost protection order or a judicial review costs capping order. Aarhus protection under CPR 4542 is specific to a claimant who's a member of the public. There is provision, however, dealing with where there is more than one claimant. And so if an interested party wants to support a claim, it is possible to consider making a complementary claim of its own, if you're in time, rather than participating as an interested party, if you want the benefit of Aarhus cost protection. Now, it could be in some circumstances, in order to avoid that additional step, you might be able to persuade the other parties to agree to deal with your costs on the basis that they would be if they were covered by Aarhus. But if you can't reach agreement, that is another way of doing it. And if you want a judicial review cost capping order, that can only be applied for by a claimant, as the Criminal Justice and Courts Act provides. But if the claimant is protected, an interested party who's supporting the defendant may recover its costs, but only up to the limit of the cap and after the defendant's costs have been accounted for. So generally speaking, there might not be anything or much left over once the defendant's costs have been swept up. And if there is an Aarhus cost cap, the interested party can seek to vary it. And I've identified a case that establishes that in the final footnote. Next, I want to turn to the question of the duty of candor and its implications. Now, the duty itself should hopefully be familiar, but I've summarized the nature of it there in the first sub-bullet point, just in case anyone is not familiar with it or wants a reminder. And it's that parties must ensure that all relevant information, all material facts are put before the court whether it supports or undermines the case, and that includes material which may reveal additional potential grounds. And that's been described as reflecting the fact that judicial review is a game played with all cards face up on the table. And so far as the role of interested parties and the application of the duty to interested parties is concerned, there isn't any case law that I'm aware of that definitively rules that the duty applies to interested parties. But if you look at the Admin Court Guide at paragraph 14.15, what it says is that it has been recognised as applicable to interested parties, and then it gives a footnote to the Belize Alliance case, which I've identified there in the footnote, in the bullet points. And the Belize Alliance case was one where the duty was applied to an interested party, but I think it's important to recognise the particular facts of that case, where the court found that the interested party and the defendant were in effect partners in the project. So although that case needs to be understood on its own particular facts, in general and in practice, it is treated as being a duty that applies to interested parties, as reflected in the Admin Court Guide and what it says about that. And what I've done in the final bullet is just to sort of pose, as it were, the rhetorical question that might suggest why that is the case. Well, why should an interested party, someone who's got a distinct interest in this case, public interest litigation, where the court's trying to work with the parties to achieve the right result, why should they be allowed to avoid disclosing material that they possess that is relevant to that outcome in circumstances where the other parties must do so? Why should their cards not be face up on the table as well? And indeed, because of the general practice, I think it would be a brave interested party who fails to comply with the duty of candor, not least because the court tends to view any such failure with great displeasure. So far as the implications then of the duty are concerned, it applies at the permission stage and it is ongoing. So the interested party and its lawyers need to consider it at every stage of litigation. And if the interested party is a public authority, not only is it more likely to hold relevant material, but it will be expected to act in the public interest, reflecting its status. And so it's important to consider what you might be required to disclose or explain before you choose to get involved, because as soon as you get involved, the duty bites and you are at risk if you have not complied with it. So then we'll turn to some practical points about cooperation with the defendant. And I focused in these slides on cooperation with the defendant rather than the claimant, because although most of the points are common in both circumstances, there are some additional subtleties that arise where you're dealing with a defendant. And so I've looked at it from this perspective. The benefits of cooperation are hopefully fairly obvious, but they include obviously making sure that your approaches are consistent and complementary to one another, that you're not taking lines in your pleadings or in court which are inconsistent. It's also, frankly, quite helpful to have two minds or more, depending on the number of lawyers involved, when considering how to approach and tackle common issues. You may find that a different perspective allows you to make a much more effective presentation and gives you an additional angle to explore. And those things quite commonly occur where you've got more than one lawyer looking at the same issues. There's also, in appropriate cases, scope for burden sharing. So one party, even an interested party, might take up the burden on one particular issue, so as to allow the defendant to focus on other points and use their time in court most efficiently. There are limits, of course, on what's appropriate in terms of cooperation, particularly where you've got a defendant involved. And that is because if the decision is ultimately quashed, the defendant will become the decision maker once again, or at least commonly that will be the position, and would then be called upon to resolve issues that are in dispute between the claimant and potentially others and the interested party, and to do so on a basis which is independent. And therefore there is a need to maintain a certain appropriate distance from the interested party, recognizing that for the moment you have some specific interests in common, in order to enable the parties then to resume their normal roles in the event that the decision has to be redetermined. So far as practicalities are concerned, the first point hopefully is relatively straightforward. If you're putting in, say, written evidence, a witness statement, appending documents, there's no point both parties putting in the same documents or covering the same matters without adding anything to one another. That just leads to duplication, additional unnecessary paper. So that sort of practical coordination of the production of evidence is important. It's also sensible, if the defendant is willing, for the interested party to share draft pleadings in appropriate cases in order to allow the defendant to point out any things which are inconsistent with the case that it intends to run. And sometimes the defendant may be willing to reciprocate, but that very much depends on the circumstances and the lawyers and the sensitivities involved in the particular case. And similarly, in terms of oral submissions, you want to make sure that the interested party is not just covering the same things, and therefore a certain amount of sensible coordination to enable parties to prepare accordingly and appropriately, and not to end up covering the same ground and wasting time. Some tactical considerations, taking different or additional points. Well, first question, does your additional or different point risk undermining the defendant's position? So are you saying, for example, that there's a particular policy, the interpretation of which might be an issue? Are you taking a different interpretation? If so, what might that do by way of undermining the defendant's primary case on how it sees the policy? Similarly, do you have an argument which depends on a different understanding of the facts? Again, might that undermine the defendant? And as I've said, well, what happens if your argument, your different or additional point fails? Are you willing to accept the cost risk if that is the outcome? Then making the best use of your time in court. Interested parties will be kept on a tight leash by the court. You won't be allowed to repeat submissions, and so you have to consider what's likely to help. Well, clarifying factual points. Court generally likes that. It's a useful role for an interested party. Dealing with specific additional points of law. Again, that can be helpful. You might want to return to a point that the defendant has clearly struggled with and perhaps put across some short, pithy points on what looks to be the key issue for the court to resolve. But certainly you don't want to end up repeating or wasting your time by taking too long to get your points across. Then appeals and finding the quickest route to a safe decision. The interested party can appeal an adverse decision even if the defendant chooses not to. And I said I'd come back to the Heathrow case, which is a prime example of that, where when the government lost in the Court of Appeal, the interested party, Heathrow Airport Limited, perhaps because it had different motivations, took the case to the Supreme Court and won. So that if you're involved, you have the opportunity to do that if the case warrants it. But also sometimes appeal might not be the quickest way to a safe decision in the interested party's favour. It may be quicker in some cases just to let the decision be redetermined if the substantive outcome is likely to be the same. And then finally, looking at the end of the process, consent orders, if the interested party has been actively involved, then it should be signing the consent order. And you should look carefully at the contents. Some defendants, government legal department is an example, are very adept at dealing with consent orders. They know what to put in the schedule so as to maximize freedom of maneuver on redetermination. Others are less so. And so an interested party can provide a useful guide and having an active role in shaping what goes into the consent order can be important. When a decision looks likely to be quashed, if that's the way it looks like it's going, interested party can sometimes seek to anticipate what will be important on redetermination, try and achieve a soft landing by making submissions to hopefully steer the court in its judgment to findings which are easier to deal with at redetermination, and seeking therefore judicial guidance on points that might, if they're not properly dealt with, need to be picked up in a second round of judicial review. And then finally, as I've said, when you get to the stage of the proceedings coming to an end, an arm's length relationship needs to be resumed between the defendant and interested party. So Richard, those are my thoughts. That takes me, I think, slightly beyond my allotted time, for which I apologise, but there we are.
Excellent. Thank you very much indeed, Harry, for that. That was great. Just a reminder to everyone, please, if you've got questions, do use the Q&A function on the system to ask them. Our next speaker is Jasveer, so I'll ask her to share her slides. Jazz is an of counsel in the public and administrative law team at Herbert Smith Freehills. She's got substantial experience of judicial review proceedings and statutory challenges acting for private sector clients and public bodies. And her experience covers public law, human rights, freedom of information, all sorts of regulatory issues, and planning and environment judicial review as well. She regularly acts for all parties in public law disputes, including interested parties and interveners up to the Supreme Court level. And she's been involved in various interventions in the Supreme Court, including in relation to the bedroom tax and the human rights compliance of the immigration system. And Jazz has previously been recognised in the Lawyers Hot 100 and is currently recognised in both Chambers and Legal 500 for her work. So Jazz, over to you.
Thanks very much. Hello everyone, so thank you very much for inviting me to speak to you today. As Richard said, I've done a number of interested party planning judicial reviews, sort of along the vein that Harry's just been talking about, but also been lucky enough to assist a number of clients with third-party interventions. So it's that aspect that I'm going to talk about today. Perhaps the most, it's always useful, I think, to set some examples. So perhaps the most high-profile example of a third-party intervention in the last few years, and one that HSF was involved in, is the Miller case in 2019 against the Prime Minister related to the prorogation of Parliament. And in that case, HSF acted for Sir John Major as an intervener. Other recent examples that I've personally been involved in are listed on the slide. So RR was a case about the sort of constitutional implications and powers of tribunals, and that was in the context of the bedroom tax. The McLaughlin case, I acted for Child Poverty Action Group. That was about widowed parents' allowance not being limited to married parents only. And then the AM Zimbabwe case was a case for the AIR Centre, which is a charity that gives free legal advice on EU law issues relating to removal from the UK, where that gave rise to adverse health consequences. So third-party interventions have really become very much an accepted part of the judicial review process. There are different categories, I think, of interventions, and they sort of they reflect who's intervening and why. So the first category is the public interest intervention, and these are organisations such as Liberty, Justice, the Public Law Project, the AIR Centre, and this is where you have an NGO or a charity intervening in what's typically quite a high profile, controversial test case scenario. And they will be doing it to ensure that the interests of a particular group are protected or well represented, obviously in line with their own campaigning objectives and priorities. So CPAG would get involved if it was sort of child poverty issues. The Air Centre gets involved if they are EU law issues. The second category is an intervention by a public body, which is one that you might not think of. But this is essentially where an organisation that's responsible for or has a particular interest in kind of the area of law gets involved. So an example is the Equality and Human Rights Commission, which often gets involved in cases that relate to its work. Or alternatively, what I've seen is that if you've got a particular piece of legislation that's the subject of the litigation, then you may see the sponsoring government department get involved as an intervener, because obviously they're best placed to speak to that legislation. Then the third category is what you might call a private interest intervention. And this is where you have an organisation that represents more the commercial interests of particular organisations. So, for example, if there's a measure, a new piece of legislation coming in that's going to impact a particular industry or sector, then you can see that the trade association in that industry or sector may think it's appropriate to get involved as an intervener, because they can really reflect the interests of the sector or the industry as a whole, and their members generally. It's worth remembering that interveners don't have any inherent right to participate in proceedings. And so when the court is looking at whether to allow an intervention, it's going to think about what the benefit would be to outweigh the inevitable administrative burden of adding another party to litigation. And that's sort of reflected, I think, on the quote that's on the slide. So you yourself, if you're thinking about getting involved as an intervener, you need to ask yourself the same question: what can I bring to the table that's different? Could it be, for example, that you've got some particular expertise or experience, and you might be able to highlight a consequence of a measure that nobody else has appreciated, or you might be able to help the court put a measure into its wider context? Might it be that you've got some additional legal arguments that the existing parties aren't already making? So particularly one case I think that stands out to me is a case where they had started in the immigration tribunal, and the claimant's lawyers had sort of no experience really of appearing before the higher courts. And when it reached the Supreme Court, our client intervened, and we were able to instruct pro bono a really experienced QC who was sort of an expert in that area of law. And we were able to present 2 or 3 additional legal arguments to the Supreme Court that really bolstered the case. And then actually at the hearing itself, it was our QC, so the Interveners Council, that dealt with a lot of those really tricky questions and the kind of back and forth in the Supreme Court. And that was a case where, sitting in the hearing, it was very obvious what value an intervention can add when you've got, an experienced intervener that knows that area, has real expertise in that particular area. Might it be that you are in a unique position to provide some evidence that nobody else can provide? As Sir John Major was, the only litigant other than Boris Johnson who had experience of proroguing Parliament. And in fact, the Supreme Court referred to that unchallenged evidence of Sir John Major, that he'd never known the government to need as much as 5 weeks to put together its legislative agenda. So depending on what you think you can add and what your own objectives are, it's worth first thinking about whether you can do that behind the scenes. So could you do that without actually getting involved in the litigation? Could you, for example, just share your evidence with the parties and allow them to use it? Could you help out with legal research or thinking of additional legal points? It's also worth thinking about how your points are going to impact the position of the main parties. Particularly, for example, if you've been invited to intervene on the side of one of the main parties, but actually the only way that you can say something different is to say something that might risk undermining their position. So, for example, because of their particular fact pattern, obviously they're not really going to thank you for that, and you do need to think very carefully about whether you should be getting involved in those circumstances. So if you've been through all of that thought process and decided that you would like to intervene in judicial review proceedings, what do you then have to do? I'm going to focus first on the civil procedure rules for the High Court and the Court of Appeal, and then say a quick word about the Supreme Court later. But from the CPR, this comes from 5417, which provides that any person can apply for permission to make representations or to file and serve evidence in a judicial review, as long as they do it promptly. And of course, we know that CPR 54 likes that word. It is really important because by the point that you make your application to intervene, the proceedings are up and running, and so they're already on a timetable. And you obviously don't want to delay a hearing or in any way prejudice the position of the parties. In practice, applications to intervene are made at the stage once permission for judicial review has been granted, or if you're in the Court of Appeal, once permission for appeal has been granted. And really, once that's happened, you should be aiming to get any application in as soon as you possibly can. Now, although you have to be prompt in making your application, unfortunately, that doesn't actually mean that it will become clear promptly whether or not there'll be an intervener, because the court then has to determine that application. And there is really significant variation in how long it can take the court to do that. I've been in a situation where a week before the hearing, we still didn't know whether we had permission to intervene or not, having made the application months in advance. You know, what do you do in that situation? Well, you have to assume that you're going to get permissions. You have to prepare all of your submissions on that basis. You obviously politely and tactfully remind the court that your application is still outstanding. And then you keep the weekend before the hearing free so that you can frantically put together supplementary bundles when you eventually get permission the Friday before the hearing. Hopefully that doesn't happen too often. Before you make your formal application, you should be contacting the parties, flagging up that you want to intervene and seeking their consent. This is something that the court will take into account, and obviously your position is significantly strengthened if you're able to say that you've got consent from the main parties to the proceedings. Having said that, my experience is that you won't always get consent from both sides. Obviously, the side that you're potentially assisting is much more likely to be willing to consent than the other side. In my experience, where I've been acting for NGOs and we've had GLD on the other side, I think GLD are a bit less willing to consent to interventions than they were, say, 10 years ago. That's okay. It's by no means the case that you won't get permission just because one of the parties hasn't consented. It's obviously useful to have that paper trail showing that you've acted responsibly, you've put the parties on notice, you've explained why you want to intervene. And actually, if any really specific points are raised as objections in that correspondence, it does give you the opportunity to think about them and perhaps address them in your actual application to the court. So it can be useful in that way. It's also at this stage worth thinking about contacting any other potential interveners. Again, the parties may be able to put you in contact if there's somebody else that has approached them. So if there are other organisations that are interested in getting involved. For obvious reasons, the court isn't overly keen on having multiple interventions in any one set of proceedings. And so if you do know of another organisation that may be interested, it is worth considering, and certainly in at least one case we were ordered to consider whether a joint intervention might be possible. That's not straightforward because you then have two organisations with slightly different priorities, potentially different legal representation by that point. But in the interest of the overriding objective, you will often be asked to see whether you can work together just to streamline the intervention process. And then you make a formal application to the court in the usual way and serve it on the parties. So you identify the claim. Who are you as an organisation? Some background, what are your objectives and priorities? What's your expertise and experience? Why do you want to participate? On what issues do you want to participate? How do you want to participate? So do you want to be able to make all submissions at the hearing? Or do you want to make written submissions? Or do you want to file and serve evidence? And then also any prospective costs order that you might be looking for. And I'll come on to costs in a bit. It's worth, before we move on, just touching on, you'll probably be aware that there have been some recent changes to Part 54 and practice directions, and those came into force just a few weeks ago. A couple of ways that they impact interventions. Firstly, if you want permission to make representations at the hearing, then you should put a summary of those representations in your application. Now, from my perspective, I've always put a summary of those representations in my application anyway. It's just that sometimes that summary has been, a few sentences, sometimes it's been a few pages, depending on the circumstances. So it's a little unclear, I think, how much detail the court is looking for here. What will they be expecting? And that's just something that will become clear as sort of practice continues. The second change, which I think is more troublesome, is that if you are seeking permission to file and serve evidence, you actually have to attach a copy of that evidence. Now that's difficult because, of course, at that point, you don't know whether you're going to get permission to intervene or not, and yet you're having to incur the time and cost of preparing that evidence. Now, bearing in mind that most interveners are sort of trade associations, NGOs, charities, not large commercial organisations, so that often interventions are done on very, very tight costs. I think this will also impact how promptly you can make your application, which is slightly at odds with the court's emphasis on that, because previously you could just decide that you were going to intervene and then you could sort of get on and do your application as soon as you could. Now, of course, that's going to be delayed while you actually prepare your evidence. So I do think that second change is potentially difficult, and we'll have to see how that works in practice. So turning to costs, I think historically interveners would generally ask that there should be no order for costs made against them, regardless of the outcome. And that was, I think, generally accepted to be an appropriate position. In 2015, Section 87 of the Criminal Justice and Courts Act came into force. The general presumption is still that interveners should bear their own costs, subject to exceptional circumstances. Well, that's fair enough. But the bigger problem is that there are certain situations in which the court should be ordering interveners to pay costs towards the other parties. And those situations are the ones I've listed on the slide. So the intervention didn't significantly assist the court. It wasn't really relevant to the main issues in the dispute. The interveners ended up acting essentially as one of the parties because of sort of taking on an expanded role for whatever reason, or the intervener has acted unreasonably. Now, when this rule came in, I think we and many others were quite concerned that it would lead to sort of a downturn in interventions because a lot of organisations would be concerned about the cost risk. I have to say, in my experience in those years, I haven't seen the courts sort of handing out cost orders against interventions willingly, as long as those interventions are done responsibly. So as long as you bear in mind your role as an intervener and your impact on the proceedings throughout. So you aren't duplicating or repeating what the other parties are saying. You are very clear about what issues you want to be involved in. You stick to any limits that the court imposes. So often the court will say, oral submissions of 30 minutes or written submissions of 20 pages, and you must stick to those. Also, just generally being cooperative. So, not being the only party who refuses a short time extension from one of the other parties, for example. And keeping your position under review as the proceedings progress. So just earlier this year, we had a client who wanted to get involved in an ongoing piece of litigation on one very specific issue. That was really the only issue that they were concerned by. So we put in an application to intervene. And then as the proceedings progressed, it became clear that that wasn't really an issue anymore. It sort of dropped out of the picture. And we wrote to the court and the other parties and said, actually, this was the only thing that we wanted to really talk about. It's no longer an issue. So in the circumstances, we're going to withdraw our application. And that was the responsible thing to do in that situation, rather than having that continued administrative burden of an additional party who actually no longer really needed to be there. So I think as long as your intervention is done in that way, the courts don't generally hand out these sort of costs orders. And we do, when we write to the parties, we'll often ask the parties to confirm that they won't seek a costs order. Again, you're usually more willing to get that from the party that's on the same side rather than both parties. And ultimately, it comes down to the organisation and their appetite for costs risk. So turning very quickly to the Supreme Court, we've spoken so far about the High Court and Court of Appeal, but most interventions, I think, end up happening at the Supreme Court. And you can either intervene in the application for permission by way of written submissions, or once permission has been granted, you can intervene in substantive appeal. Now, as with all Supreme Court litigation, you have to look at the Supreme Court rules and the Supreme Court practice directions, and it's Rule 26 that provides for interveners in the substantive appeal. And it specifically envisages that if you were an intervener below in the Court of Appeal, you may consider wanting to apply again. And then there's a specific form and you would just fill it in the normal way. The practice direction from the Supreme Court does actually set out a quote, which I've put out on this slide, which I think really encapsulates the view of the Supreme Court towards interventions. So the House is frequently assisted by the submissions of statutory bodies and NGOs on questions of general public importance, and grateful to such bodies for their help. But of course, it's of no assistance if it's just repeating points which the appellant or the respondent has already made, and it's not your job to be an additional counsel for one of the parties. Now, I should say against that, there have been lots of positive statements from the courts about interventions. And I've been involved in a number of cases where our evidence or our submissions as an intervener ended up being referred to quite extensively in the eventual judgment. And the court made it clear that they were grateful for that help and assistance. But obviously, it's a slightly guarded view, as you can see from the costs rules, the most recent changes to the CPR, and some of the comments from the senior judiciary. I think ultimately, to sum up, interventions can have a really important role to play in the development of the law in the public interest, as long as they are done in a really targeted, precise and responsible way, not only to avoid or to minimise the chances of facing a costs order against you, but also, I think, importantly, to try to sort of preserve the reputation of interveners amongst the judiciary so that we maintain a positive attitude towards interventions. That was all I wanted to say. I think I've managed to finish just within 2 o'clock.
Thank you very much indeed, Jazz. So we'll move on to questions now. We've got time for 2 or 3. And Jazz, there was just one thing I was going to pick up with you, if I may, in relation to your presentation, which was the position of the government in relation to interventions. And there was a case that sprang to mind when you were talking from 2010, I think, in the Court of Appeal, which I've just looked up, that the court there said, "We note with approval that in public interest litigation, Treasury Counsel today do not stand in the way of interventions unless they consider that there's good reason to do so." And I just wondered what your view was on whether that's observed today in light of my experience, which, for example, in one case where I was applying on behalf of an intervener, the Treasury solicitor did object for no good reason, in my opinion, in that case. So I was just wondering what your view was on whether what was said by the Court of Appeal then in 2010 is actually still the case in practice.
I think it's not so much as it was in 2010. Certainly, I think in the last few years we've seen, and this is across the board because we act for a number of different organisations. So it's not, they just don't like one organisation. There is much more reluctance to consent, or, for example, there will be consent to written submissions only. Certainly much less willingness to confirm they won't seek costs against an intervener. I think it's been a long time since I've seen the government agree to that at the outset. Which used to be the case quite routinely, actually, 10 years ago. There's obviously pressure on hearings, I think. Often, if you've been set down for a day or a day and a half hearing, then that's often given as a reason. Recently, I've had one where we intervened in the High Court and the Court of Appeal, were referred to quite extensively in the Court of Appeal. And then when we went up to the Supreme Court, the government said, well, you've already appeared twice, so you don't need to come again. Those sorts of things, which you'd sort of have thought by that point that they'd have understood. Actually, this was a useful intervention, and both the courts below thought it was. I think it's unfortunately not the case so much anymore as it was in 2010.
Thank you. Harry, a question for you in relation to the CPRE Kent branch case, which you mentioned we're awaiting for the Court of Appeal outcome. And we're asked whether you've got any thoughts on how the Supreme Court might rule in that case.
Well, I should start by putting in place the important caveat that I have not watched the proceedings in the Supreme Court to get a flavour of how it went. So I can only base what I say on reading of the Court of Appeal's judgment. But at the risk of being proved wrong within a very short period of time, my instinct is that the way that the Court of Appeal approached it is probably pretty persuasive. It seemed to me that the rationale they gave for the approach taken is really quite attractive, not obvious why it's wrong, but also in practical terms, it preserves a wide discretion for the court to make the right order to suit the circumstances, but is accompanied by what seems like quite practical guidance on how that discretion ought to be exercised. So from a judicial point of view, what's not to like about the approach that's taken? It removes what would otherwise be an apparently unjustified specific hurdle or specific constraint on the exercise of their discretion, and leaves it open to the judge to make the right order in the circumstances. Doing my best, that would be my instinct as to the way I think the Supreme Court would go, but I'm quite likely to be proved wrong.
Well, we shall see. Jazz, a question for you, which is in relation to courts allowing interventions over the last 10 years or so. Has there been a change in the extent to which courts are willing to allow oral submissions as opposed to just written submissions or evidence?
I think there's been a reduction in the amount of time you get. So it used to be quite routine to get an hour. Now you generally get 30 minutes. Again, I think, pressure on court time, court resources, sort of trying to make hearings run more efficiently. I don't think the courts have been less reluctant to allow written submissions, definitely. They do understand the value of those. And there's been cases where written submissions are really helpful. I think there may be a bit of a reluctance to allow new evidence. And I think that's what that recent change to CPR is about, actually really forcing an intervener to stop at the very beginning and think, do I need to add this new evidence? Now, there's some situations where you do need to add that new evidence. There's a case that we did on the benefit cap for Child Poverty Action Group, where tables were produced, and they were incredibly helpful for the court to sort of see the real impact of the benefit cap. So that evidence was really important. But I think it is just aimed at making the intervener stop and think, do I need to add new evidence? So I think generally still positive, but within limits, and those limits do seem to be getting a bit tighter.
Yeah. Excellent. And then one final question, which I'm going to ask Harry you to comment on, please, which is if your client is in a position of being able to perhaps argue that it should be recognised as an interested party or make an application to intervene, which of the two would be better, or what are the advantages and disadvantages if you're in that position of being able to go either way?
I suspect, Richard, that if you've got a good case to say you're an interested party, that's probably going to be advantageous, because if you are an interested party, then provided that you follow the rules, you should be entitled to take part. You don't have to go through all of the steps that Jazz has been outlining in order to try and get your place at the table, incurring a lot of expense when you might just be unsuccessful. So I think that's a pretty key distinction from my perspective. And if your interest is going to be the same either way, then I would have thought in terms of the costs consequences, they shouldn't be substantially different. But the fact that you don't have to make your application to get your place in the litigation seems to be probably the key distinction.
Excellent. Well, I'll draw it to a close there and just say thank you to both Jazz and Harry for 2 excellent presentations and also engaging with the questions. Thank you very much indeed. And for those who are with us still, thank you very much indeed for staying with us. And just to let you know, our next FDB Public Law webinar is on the 1st of July at 4 p.m, where we're going to be talking about the delightful new topic of retained EU law. So thank you very much, and we'll look forward to the next time.
Thank you.